Hello everyone, and welcome to the September 2024 episode of My PIP Monthly. As always, I'm Executive Partner Amber Rouse Holloway from our Troy office. This month, our September 24 topics include a case law discussion. We'll be discussing some older cases, and by older I mean 2021 and 2022, both unpublished opinions. First up, the case of Margot Paraji v. Edward Chotnicki, and that one was issued on November 2nd, 2022. And then next up will be the case of Michigan Spine and Brain Surgeons v. Homeowners Insurance Company, which was issued February 18th, 2021. For our trending topics in PIP litigation, I wanted to discuss reasonable fees for treating physicians when you depose them as witnesses and obviously not experts. And in support of my position, I wanted to highlight an unpublished opinion, Johnson v. State Farm Insurance Company, which was issued on November 22nd, 2022. Now, just a brief shout out to my firm. This matter was represented by Secrets Water on appeal, but ultimately here the court found that for a defendant to secure summary disposition, he must lay the documentary foundation necessary to uphold the assertions which he alleged entitled him to summary disposition. Now, ultimately, this case highlights the importance of laying a sufficient evidentiary foundation for summary disposition at the very onset of the issue and how holes in that foundation can lead to some dire consequences. Now, just a brief background on this one. This involved a motor vehicle collision with a ORV or off-road vehicle. Although the nuanced facts regarding how the accident arose are disputed by the litigants, the facts of the accident can be distilled into the two vehicles colliding as they both moved to the left near an intersection in a rural area of Michigan. And moving for summary disposition, the defendant, represented by Secrets Wardle on appeal, asserted that he saw the ORV pull out of a private drive in front of him and enter into the middle of the roadway in front of him. As the defendant's vehicle grew closer to the ORV, he decided to enter to the left lane to pass the vehicle, the ORV. However, as the two neared the intersection, the defendant alleged that the ORV initially appeared to veer right before swiftly making a left-hand turn directly into the rear of defendant's vehicle, thereby jetsoning the minor driver from his ORV. Now, in his motion, defendant asserted that he should be entitled to relief on the grounds that the ORV was illegally operated on the roadway, namely due to its operation by an individual under the age of 16, amongst other issues. The lower court agreed and granted summary disposition. Overturning the ruling of the trial court, the Court of Appeals first evaluated the burden of proof necessary for a party to properly obtain summary disposition. Now, since the initial burden rests on the moving party to support their claim by way of affidavits, depositions, admissions, and other documentary evidence, they cannot simply rest on mere allegations to support the facts of their position. In documentary evidence, a partial excerpt from the applicable police report and the local county ordinance governing the uses of ORVs was attached to the motion. But ultimately, the court found both failed to satisfy the initial burden of proof necessary to support summary disposition. Now, in regard to the police report, the court noted that police reports are generally considered inadmissible evidence. We all know that, but could potentially be admissible in the context of a document prepared in the ordinary course of business. Now, in this matter, the court found that the cited experts in the partial report were insufficient to support motion for summary disposition, as they did not contain any factual allegations or witness statements regarding the circumstances of the accident. The court further asserted that even if the entire police report was to be included in the record, it would still be insufficient, as the moving party failed to lay the foundational groundwork necessary for demonstrating that the police report fell within the exception of the hearsay rule. Now, notwithstanding these evidentiary issues that we just talked about, the court likewise found that the ultimate issues constitute a question of fact for which summary disposition was inappropriate. In this regard, the court first addressed the minor operation of the ORV and the requirement that the county ordinance for ORV operators be at least 16 years old. In noting that the violation of the statute created a presumption of negligence, the court opined that the violation of the statute must be the same type of injury and harm the statute was designed to protect against or prevent. In other words, there must be a correlation between the ordinance and the injury. Now, in this case, the court found that the ORV ordinance was designed to ensure that the minimum qualifications and training for operators of an ORV and not to benefit a negligent driver by presuming that an ORV operator was negligent for administrative deficiencies. Taking all this together, the court found that the defendant in this matter, in order for the defendant in this matter to secure summary disposition, it was incumbent on him to lay the documentary foundation necessary to uphold assertions which it alleged it was entitled to for summary disposition. Now, without the foundation, the court found that it did not have enough record to sufficiently find that the defendant was entitled to summary disposition as a matter of law. But the big takeaway here from this case is that the absolute necessity to properly lay the foundation for argument and not simply assert a position and leave it for the court to search for the foundation on its own. Now, simply put, in the evidence-based court system that we find ourselves operating within, it's imperative for litigants to properly brief their issues and lay the foundation for why the requested relief be granted. Now, next up, we have the case of Michigan Spine and Brain Surgeons v. Homeowners Insurance Company. Now, in this case, the defendant failed to assert fraud in a PIP action against the underlying plaintiff and instead settled. Now, the defendant was then barred from raising the issue of fraud against assignee plaintiff, Michigan Spine and Brain Surgeons. Plaintiff here appealed the trial court's order granting summary disposition in favor of defendant due to defendant's argument that the named insured, Amila Hosey, committed fraud. Now, ultimately, the court ruled that the trial court erred in granting summary disposition to defendant as res judicata, barred defendant's claim that the underlying claimant, Amila Hosey, committed fraud. Now, as an assignee of Hosey, plaintiff, as we all know, plaintiff here meaning Michigan Spine and Brain, stands in the shoes of the claimant, possessing the same rights and being subject to the same defenses. Now, plaintiff made 3 arguments on appeal here. 1, that the trial court erred by concluding that Hosey made false statements. 2, the trial court erred by rejecting plaintiff's argument that rescission was inappropriate as plaintiff was the innocent third party. And 3, defendant was barred under res judicata and collateral estoppel. Now, in order to satisfy collateral estoppel, 1, there must be a question of fact essential to the judgment, and it must have been actually litigated and determined by a valid and final judgment. 2, the same parties must have had a full and fair opportunity to litigate that issue, whatever the issue is, here being fraud. And 3, there must have been mutuality of estoppel. And then res judicata, which is similar, but there are some nuance. 1, the prior action was decided on the merits. 2, both actions involved the same parties or their privies. And 3, the matter in the second case was or could have been resolved in the first case. Now, the whole purpose of the doctrine of res judicata is intended to relieve parties of the cost of multiple lawsuits regarding the same issues, regarding the same parties, and encourages reliance on full adjudication, that is to foster the finality of litigation. And that's quoted from the case of Garrett v. Washington. Now here, the court ultimately said that the settlement between defendant and Hosey barred defendant from asserting the issue of fraud against Hosey. Therefore, defendant is also barred from raising the issue of fraud against plaintiff, Hosey's assignee, who possesses the same rights of Hosey, who is protected by res judicata from defendant's fraud assertions. So basically, that case is important because if you have that fraud issue, it should be litigated. If you see that fraud issue very early on in the case, which in most situations we do, it's important to litigate that now and then instead of waiting until you get multiple provider suits to bring up the issue. Now, moving on to trending topics in PIP litigation. I did want to briefly discuss reasonable witness fees for treating physicians. I've seen a trend where treating physicians, plaintiffs treating physicians or claimants treating physicians are requesting astronomical fees to be deposed. And they're being deposed as treating physicians, as witnesses, and not as experts. But they're charging fees. For example, a recent case of mine, the doctor was charging $1,500 per hour to be a witness, which is absolutely crazy. This doctor had never testified in a deposition before. She would not have been qualified as an expert. Frankly, when I requested any prior information regarding expert testimony, she provided none because she couldn't. So to charge expert fees when you haven't provided an expert opinion is somewhat disingenuous, in my opinion. Now, this matter is controlled by MCL 600-2552, which essentially states that a witness who attends any action or proceeding pending in a court of record shall be paid a witness fee of $12 a day and $6 for each half day, or may be paid for his or her loss of working time, but not more than $15 for each day shall be taxable as cost at his or her witness fee. So what that means is $12 a day, or whatever time they're missing from work, how much that would cost. But no more than $15 of that time is taxable. This issue is also controlled by MCR 2.302B4C, which states that a party seeking discovery must pay the expert a reasonable fee for time spent in a deposition, but not including preparation time, and the court may require the party seeking discovery to pay the other party a fair portion of fees and expenses reasonably incurred by the latter party in obtaining facts and opinions from the expert. But again, especially specific to my recent issue, this treating physician was not an expert. Now, there is case law to support these positions, and I will briefly discuss an recent unpublished opinion, but this next quote is from a 2016 published opinion that essentially states that a treating physician is not automatically considered an expert witness solely because they are providing testimony about their care and treatment. Now, the Court of Appeals expanded upon the common understanding of expert witness fees as one that examines the facts from a distance, offers opinions, and has no financial stake in the outcome other than receiving a court-approved witness fee. Now, this unpublished opinion, Johnson v. State Farm, issued November 22nd, 2022, involved two treating physicians and their uncooperativeness in discovery within an underlying PIP case, which ultimately led to the Court of Appeals ruling that the trial court abuses discretion by failing to impose a lesser penalty of sanctions for plaintiff's discovery violations versus its granting of summary disposition. Now, here the court indicated that regardless of the physician's constant refusals to testify absent any expert witness fee, plaintiff submitted evidence of causation that should have survived summary disposition. Now, here this court was remanded to the trial court to order an appropriate discovery sanction for plaintiff. Now, in this case, the treating physicians would not cooperate, did not want to be paid the typical witness fee, but did want to be paid an expert fee. And the court pretty much said no. All that the defendants are required to pay is this witness fee. And essentially, the two treating physicians failed to show up, and the court ultimately dismissed the plaintiff's case. Now, the court here is not saying that they will the Court of Appeals is not saying that the witness fee was not applicable or not appropriate. They're saying that dismissing the plaintiff's case ultimately because of these two treating physicians was not appropriate. And that is all I have for you guys today. As always, thank you for attending the September 2024 episode of My PIP Monthly, and I welcome any questions and or concerns.